Good day everyone, my name is Opeoluwa Oluwasiku. I am a 300 level student of the Faculty of Law, University of Lagos, and currently a virtual legal intern in HARLEM's Telecoms Academy, powered by HARLEM solicitors. I will be lecturing us briefly on the topic Balancing National Security and Individual Privacy, the Ethics and Legalities of Lawful Interceptions of Telecommunication in Nigeria. By the end of this lecture, you would have been able to gain full knowledge on the concept of the lawful interception of telecommunications in Nigeria, limitation of telecommunications companies in Nigeria regarding access to information of telephone conversations, the relevant legislation in Nigeria governing telecommunications, the potential conflict between interception laws and constitutional rights, the need for the balance of national security and the right to privacy as relating to lawful interception in telecommunications, and the legal framework for lawful interception, creating the balance between national security and the right to privacy. Lawful interception of communications refers to the legally authorized process of monitoring or intercepting telecommunications, such as phone calls, emails, or text messages. Ordinarily, telecommunications companies do not have the authority to have access to the information on the conversations and discussions that transpires during a telephone call. They only have access to the call detail record, also known as the CDR, which can disclose the date, time, duration, completion status, destination number, as well as the originating and terminating towers for the call. However, the principal legislation regulating all forms of telecommunications and internet-based communications in Nigeria, which is the Nigerian Communications Act of 2003, provides in Section 147 and 148 that the Nigerian Communications Commission, hereinafter we refer to as the NCC, may determine the requirements and capabilities of a licensee to authorize interception of calls and may suspend this license during a public emergency for public safety. I must mention that the NCC is the body pursuant to Section 70 of the NC Act 2003 charged with the responsibility for regulating communication system in Nigeria. It may be justifiably argued that the aforementioned provisions of the Nigeria Communications Act is inconsistent with the constitutional right of the people to privacy pursuant to Section 37 of the 1999 Constitution of the Federal Republic of Nigeria, which is the ground norm of the Nigerian state, which specifically protects telephone conversation and telegraphic communication with no exception whatsoever. This then raises a question as to the extent to which interception can become lawful without breaching our right to privacy. To adequately answer this question, recourse must be made to Section 45 of the Constitution, which provides that a law can make provision for the interception of communication. It curtails the enjoyment of the right to privacy insofar as it is reasonably justifiable in a democratic society and to the interest of public defense, public safety, public order, public morality, public health, and the purpose of protecting the rights and freedom of other persons. This inevitably calls for the need for a balance between the rights of people's privacy as well as the expediency for national security, for the preservation of democratic principles, to protect civil liberties, to prevent abuse of power, and to foster trust between the citizens and the government. On the backbone of this section, the NCC enacted the Lawful Interception of Communications Regulation of 2019, hereinafter we refer to as the LICR of 2019, for the purpose of providing the legal and regulatory framework for the lawful interception of communications, collection and disclosure of intercepted communication in Nigeria. The LICR 2019 makes provision for the identification of the key law enforcement agencies authorized to intercept communications, the instances where interception is permissible, the nature and types of communication that can be intercepted, through processes, issuance of warrants and exceptions, and also the penalties for non-compliance by any person, licensee, or its officers, and the remedies available to citizens under the regulation. Regulation 4 of the LICR 2019 provides that interception of telecommunications relates only to the use of a communications service provided by a licensee to a person outside and within Nigeria. Section 8 states the authorized agencies to apply for the warrant to intercept communication. Section 12 of the LICR 2019 provides that only the courts have the authority to issue warrants for interception. This then covers the inconsistency in the provisions of the NC Act governing interception with Section 4, Subsection 8 of the 1999 Constitution, which prohibits any law ousting the jurisdiction of the court. It also provides that no warrant is needed where one of the parties to the communication consents to the interception and has sufficient reason to believe there is a threat to human life and safety. This regulation aims to protect public safety, security, and national defense, aiding investigative powers of authorized agencies and security agencies in intelligence gathering. Some other legislation which provides for the lawful interceptions of telecommunications in Nigeria are the Terrorism Prevention Act, the Cybercrime Act 2015, to mention a few. We've come to the end of the lecture, and I do hope you're able to fully grasp and understand all that has been treated. Please do drop your comments and questions, and it will be well attended to. For more information, visit www.harlemsolicitors.com. Thank you very much.